When a complex real estate transaction fell through, the sellers tried to invoke an implied vendor's lien to take precedence over a bank in Devenneys versus Hill. David Eason offered Jack and Shirley DeVenney $250,000 for their land. The Devenneys accepted, provided they retained a lot by the road and Eason excavated this lot for them. They entered into a sales agreement under which Eason agreed to buy the land within 90 days. The agreement didn't mention the retained lot. Eason sought financing from Mason Hill and Frank Thomas. The three men agreed that Hill and Thomas would purchase the land directly from the Devenneys for $200,000, and Eason would then buy the land from them for $275,000. Shortly before the closing, Eason offered the Devenneys another $50,000 if they'd give him an extra month to pay $150,000. The Devenneys orally agreed, but the new $300,000 sales price was never put in writing. Hill and Thomas brought a check for $200,000 to the closing. Eason brought two post-dated checks, one for $150,000 and one for $50,000. The Devenneys didn't object, but they insisted that Eason had to excavate the retained lot. The lawyer added a handwritten note to that effect at the bottom of the sales agreement. All the parties signed. The lawyer gave the Devenneys a check for $100,000. The Devenneys said they were counting on Eason making the post-dated checks good in 30 days. Eason never honored those checks. The Devenneys sued. They argued that Eason had assigned the sales contract to Hill and Thomas, who breached it. They also argued that they had an equitable vendor's claim against Hill, Thomas, and the bank. Hill, Thomas, and the bank countered that the Devenneys had waived this claim. The trial court granted the Devenneys summary judgment against Eason, but dismissed their breach of contract claims and their vendor's lien claim against the bank. The Devenneys appealed to the Alabama Supreme Court.